Welcome to the Eyes on Privacy podcast, episode number 19. It's been a while since our last podcast, but we're back. This week we're with Josh Gillum, Keith Watson, and I'm Preston Wiley. And Keith will introduce our topic for this week since he selected it.
Okay. So what's interesting for this article is we're talking specifically tonight about Microsoft being held in contempt due to a court case. Basically, the United States government issued a subpoena to Microsoft to collect some emails in an investigation, and Microsoft refused to turn over the information, and its claim was that the data associated with these emails was kept in its Ireland data center, and since Ireland is not part of the United States, that the subpoena was no good. And basically, the United States government said, well, you're a U.S. company, and you can control any of the data in any of your data centers, no matter where they are, so you have to give us these records. And Microsoft still refused. And so by refusing again, they've been held in contempt of court for that refusal. So there's a lot of interesting history here. If you recall, during Edward Snowden's revelations and some of the documents that he provided, Microsoft was one of those companies named as having access or providing or having visibility for the NSA to see a lot of their data. And so a lot of customers were concerned about Microsoft, just as they're concerned about Google and Apple and all the other companies that were named in these documents as being colluding with the United States government. And so a lot of foreign companies were starting to pull back on their use of a lot of U.S. companies for cloud-based services and other stuff. And so basically in an editorial, the general counsel for Microsoft basically went out and said, look, your United States government is trying to get emails, and that's not good for the industry because that's going to scare away a lot of customers, and so we're going to court to fight this, and we'll figure out what happens. So there's a lot of interesting stuff going on here, mostly because it's basically these companies are fighting back now. And back in December, Microsoft basically said, no more NSA, man, they're just pledging that they were going to no longer or basically resist any attempt by the NSA to gather data from their services. So that was interesting. And then this is kind of an actual they're going to the mat with the courts to kind of figure out whether the government can request this kind of data. So the fact that they're being held in contempt is kind of interesting. And basically they're trying to appeal to a different court to get a different verdict in this case. So basically, they're in contempt, but the United States government has agreed that they're not going to hold any sanctions against them until they get this appeal figured out. So I think this was kind of an interesting turn of events and very interesting. So I thought we'd talk about that tonight.
Yeah, I think it sets precedents because one, they're just asking for emails now in a location that's outside the U.S., but if this gets approved or they have to get emails, then it's opened up the other can of worms of everything else you want to put on your cloud, services if your cloud's hosted elsewhere, ran by a U.S. company. So if you had, company records or personal records such as banking information for maybe accounts outside the U.S., that they're going to be able to request that information if this, depending on how this case stands, it'll be a good precedence for that, and that's sort of scary, if not super scary.
Well, from my reading of the article, the U.S. is trying to play a lot of games and try and work around this as much as they can, and basically they're trying to, from my understanding, they're trying to classify cloud services kind of as a separate thing than just, oh, you have it on a remote data center. They're trying to classify cloud services as business records for the business, so that they since they have lower legal protections than like personal data, because I mean from the term the cloud is just the term where you get basically send it to a service and it just kind of goes off somewhere, and you're kind of you don't know exactly where it's going. It could go to Ireland, it could stay in the U.S., it could go to Canada, it could go anywhere. Essentially, is how the cloud has been kind of termed, and I think as far as the government is trying to get it is, well, you didn't really specify you wanted it there, but the fact that it's there shouldn't have an impact on us legally getting it. I think it's their argument.
Right, and they're trying to reclassify email in that same way, where emails had some amount of privacy protection in law. This attempt by the government is to say, no, it's just records, it's just business records, and therefore they don't have the same level of privacy protection, and that's the troubling aspect here.
Because if you try to convert this to pen and paper or pre-technology world, it's like if someone sent me a letter through snail mail, I got that record or that letter, and then I went to Canada, put that record at my house in Canada or at my safety deposit box in Canada or whatnot, and then came back to the U.S. and kept it in Canada. It's like them trying to go to the Canadian police saying, hey, let me into this place because I want to look at this letter that he received. Is that more or less the equivalent on a pen and paper type environment?
But that is Microsoft's contention. The government's contention is that regardless of where your data center is, you can get the data from inside the U.S. So there's no need for the U.S. government to go and try to get the Irish government to issue a warrant or a subpoena to go and get those records on the Irish side, because if I submit the subpoena to Microsoft here in the U.S., they can go electronically and reach out and grab those records in the Irish data center. And Microsoft is saying, well, yes, we could. However, you can't legally ask for the data because it's not in the U.S. Even though we control it, it's not in the U.S.
I mean, email is just is equivalent. I think I'm not a lawyer, but I think the courts have basically said that email is essentially the equivalent of a mailed letter, in that you need a warrant to get it from a legal standpoint. And they've kind of said that the metadata for the email necessarily isn't protected, just kind of like the envelope that you send the letter in. You can see the address and all that, and that is less protected than the content of the letter itself. But from my understanding on what the government's trying to do is they're saying, well, yes, it's in Ireland, but the way your service works, it could just as easily have been on a server in the United States. It's just you happen to have it in Ireland right now. It could have been here, or it could have been somewhere else. It's just by chance it happened to be in Ireland. So you were whoever's email it is just happened to be lucky. So it really should be a business record and it should kind of be classified as being in the United States, because it just as easily could have been based on just an algorithm chose to put it there. I think that's probably what their argument is, essentially, is that perchance it happens to be there, but it just could have been here.
I think what we're missing, and I can't recall if it's described in any article we've seen, is whether that the email that's in Ireland is for someone in Europe or Ireland.
Yeah, that's something I don't know, but I kind of assume that since the whole process is being done in the U.S., that it's at least for some situation in the U.S. I don't know if it's a U.S. citizen or an Irish
Yeah, that's the other
citizen
question.
or anything like that. But from it's obviously U.S. courts that are dealing with this. So I would think if it was an Irish citizen, then they could fairly easily go to Ireland and say, hey, we're trying to get this data.
Yeah, because they said it was a narcotics case, and that was the only details I could find out about the case. So when I think narcotics, I think it either was grown and processed in the U.S. or grown elsewhere and then imported into the U.S. So that, is it the importer from a foreign country coming into the U.S. or is it the person on the U.S. side obtaining it? So I was like trying to think of who the people could be that they're going after. It was how I processed it or thought about.
Yeah, it's not clear. I've looked at a couple articles, and it's not clear as to whether the emails are for somebody else other than a U.S. citizen. Doesn't say.
Yeah, personally, I'm happy to see Microsoft essentially, taking it as far as they can and getting a definitive answer instead of just allowing, one court loss to say, okay, we're done, here you go. They're, I think, going to take it as far as they can to actually get an answer on do they actually have to hand over this data. I mean, there was a warrant from reading the article. There was actually a warrant for the email, so they're not trying to pull any, we don't have a warrant type thing, but which is why they're being held in contempt, because they have a warrant for the email, and they're not providing the emails that they're being requested. But I think Microsoft wants to get a definitive answer. Okay, we have something in another country. Do we actually have to hand it over? And I applaud them for that.
Exactly, and I think this is really necessary because if going back to I think it was March this year, and it might have been before that, but Microsoft has basically lost a lot of customers, foreign customers, due to a lot of these revelations, including the government of Brazil. I believe Brazil had a big contract with Microsoft to do a lot of cloud-based computing, and that contract's null and void now. So they're in a position where they need to reassure foreign customers in some way that they're not just the lapdogs of the U.S. government. And I think one way is obviously through this defiance, saying, no, we're not going to turn these over. Let's go to court and let's get it settled. Let's figure this out. I think they feel, based on the editorial in the Wall Street Journal, that they've got the they have the upper hand here in terms of constitutional law. And if they win and the government can't actually collect these emails, that's a big win, which may help reassure a lot of customers in foreign countries about whether they should trust their U.S. companies as their partners in a lot of their technology needs.
Well, I think even if they don't win, it's even if they don't win this particular case, I think it still might be a win for them. I mean, they're showing the world essentially that they are willing to fight government requests, and I think this government request is a little more, isn't completely and utterly crazy. I mean, it's a valid warrant on an email for a narcotics case and all that, but it still kind of shows the world that Microsoft is willing to push back, even if they lose. It'll say that about them. So I think either win or lose, I think it's good for Microsoft that they've done this.
Yeah, but I think it takes, if you look at just the short term of just this one case, yeah, I mean, it's a win for them, but I think they're going to have to do a lot more. If you look at the long term of what Microsoft has done and given to the NSA or given to whoever, that just one case turnaround to me doesn't show that they're a changed company, I think they would have to show me a lot more than just one case. But yes, it definitely is a good start to it.
Right. I mean, it's not going to be bad. I don't think, for the reputation, regardless, win or lose. I mean, the only bad thing they could do is, like, if the next time they get a no, they don't appeal it again. I mean, they pretty much have to kind of keep pushing, I think. But I mean, you know, how long can you push before you cut your losses, I guess, is the question for them.
Yeah,
go ahead, Josh.
I was going to say, if they do win, to me I see a huge new business opening for U.S. customers. It says, hey, U.S. customer, if you want slower speeds, but we can put your data in a non-U.S. data center and charge you a premium for it, to me it opens a whole new business model for them, or extra service that they don't really have to build too much on.
Right, and it also shows other companies as well that what essentially, it also makes it clear for other companies what I think the law is. I think this is one of those undecided legal issues, and I think Microsoft wants to get a ruling on it, a definitive ruling on it. I'm not sure how definitive they're going to be willing to go, but I'm not sure if they're going to take it as far up as they can.
I was going to point out that Microsoft is not the only one kind of doing this, but also you may recall that a while ago, and it was in April of 2013, Google started to fight against some of the national security letters it was getting in court, whereas previously they hadn't really challenged them. There was concern, and you may recall some discussion over being able to tell customers about how many letters they'd received. You know, that was a big discussion with the Department of Justice, that they and other tech companies were trying to push for the right to say, well, this is roughly how many NSLs we've received. They were actually fighting against it too. Now, this happened prior to the Edward Snowden, but I think that shows a little bit of pushback that a lot of these companies are now taking on against the government's overreach, if you will. So hopefully we'll see this continue.
Within the U.S., but if you look to outside the U.S., I think in July the British government passed a law asserting its right to require tech companies to provide emails stored anywhere in the world.
Yes.
So I think that's the sort of even more scary part. At least the U.S. hasn't had that yet.
But and who knows? The British courts may challenge that a bit too, and have a little pushback on that law. So that remains to be seen.
Well, and if it starts to hurt British companies and things like that, then that may there may be definite pushback on that, because the whole thing with the NSA and the Snowden thing has definitely hurt U.S. businesses. There's no question about that. Keith pointed out that Brazil pulled out of a big contract with Microsoft, and I'm sure that's one of many issues that U.S. companies have had after the revelations that we've experienced in the past few years.
Yeah. So I think on a whole, for the average person listening to the podcast, from a privacy perspective, this is good news in the sense that Microsoft is willing to go to court and argue that this can't be done. We'll have to wait to see what the verdict is ultimately, to see whether which side's going to win this, and whether it establishes kind of a precedence for other cases. So that'll be interesting to see. That might result in changes to the law. Who knows?
Yeah, this could be either a big win for privacy, or I think maybe a small win for privacy, just knowing that hopefully Microsoft is willing to fight for your cause if things are on shady legal ground, essentially. So I think if Microsoft wins, it's a big win for privacy. If they don't win, then there's still a silver lining in that. It looks like tech companies are starting to kind of push back against the government and try and do something to protect your privacy, even if they don't prevail in the end.
Yeah, I think it would be interesting to see, and unfortunately there's not a lot of records available, to see how customers are specifically foreign customers, whether they are leaving a lot of these services or if anybody cares at all, or they're still growing their customer base. That's very interesting. I know that a lot of other email providers, for example, in Europe, got a lot more business over the last year, but it's not quite clear whether it's really hurt companies like Amazon, Google, Microsoft, Apple, because they've lost customers. It's not quite clear.
Yeah, it's not quite clear, but I think there's been some companies that have gained, have gotten business due to these things as well. Just
as long as they're not in the US.
Privacy companies and things like that. So it's probably maybe hurt some businesses, but it may have helped other businesses out as well.
Yeah, true, and also, sadly, for better or worse, the U.S. does dominate cloud services right now. It would be good for a lot more competition in that area in other countries as well. So maybe the ultimate result of this is a greater number of competitors, and that's beneficial for us as consumers too. So not just from a privacy perspective, but from a price and feature perspective as well.
Okay. Well.
All right.
I think we've covered that issue. So I guess I'll wrap it up. Unless anybody has anything else to say about it. Nope. Okay. Well, thank you to Josh Gillum and Keith Watson. I'm Preston Wiley, and keep your eyes on privacy.